Hello, students. This is Jonathan Lipson with The Real Deal on Contracts. Today we're going to talk about covenants not to compete. If you are in my class, that corresponds to Unit 20. We'll talk about three things. Number one, what are covenants not to compete? Number two, how do courts assess them? Answer on a reasonableness test. What does that mean? Number three, what do courts do if they conclude that a non-compete is somehow unreasonable? All right, number one, what are non-competes? Non-competes are simply provisions in contracts, usually employment agreements, which provide that the employee agrees that while they are employed and for some period of time after they are employed, meaning after they've left or been fired, they will not compete with the employer. Right? Pretty straightforward. These are not limited to employment agreements. You can find non-competes in contracts to sell businesses, for example, where the seller agrees that they won't compete with the buyer after the buyer has bought the business for the same sorts of reasons. One of the trickier questions that arises is whether non-compete provisions that appear not in formal employment agreements, but instead in employment manuals or employment policies, things like that, whether those are considered to be enforceable. And those questions are really answered by the discussion we previously had on employment agreements generally. The other thing to notice about non-competes is that, in the real world, they'll often simply be labeled non-compete or non-competition. But in the world of law school, sometimes you have to really read and think about the language to decide whether it is a non-compete. Notice, too, that they are similar to but different from covenants not to solicit employees. If the employee who's in the contract tries to take some folks with him or her, that could be a problem for the employer. So a separate provision might prohibit that. Similarly, other provisions in an employment agreement might prohibit the employee from taking and using proprietary information belonging to the employer. Those are generally not evaluated under a reasonableness standard, like covenants not to compete. They're usually just enforceable. So that's what covenant not to compete is. They are assessed by courts for reasonableness, and what this means in the first instance, according to restatement sections 515 and 516, is that courts are supposed to engage in a sort of balancing test. They're supposed to decide whether the covenant is reasonably necessary for the protection of the employer or principal, the promisee, without imposing undue hardship on the employee or agent, the promisor, under the covenant. Courts are asked to balance the sort of harm of enforcement versus the harm of non-enforcement. Number two, how do they decide if these terms are unreasonable? Well, courts have typically looked to three factors. Number one, time. Number two, scope. Number three, geography. Time is pretty straightforward. How long after employment has ended is the employee prohibited from engaging in competitive work? We read the principal case for this is Fullerton Lumber. The court there said, well, 10 years, that's too long. Fine. Question then is, well, what's the right amount of time? The Fullerton Lumber court said 3 years seems to be right. And the question becomes, well, how did they figure that one out? Number two, scope, meaning the character of the work involved. Usually we look to the nature of the employer's work, or business rather, as well as the kinds of services that the employee was providing. Very often the covenant not to compete will specify what the scope is, what types of work or what have you are considered to be competitive with the employer. Very frequently, you just have to look at the nature of the position the employee might have had. Number three, geography. How broad a range physical geography does the non-compete cover? In a world before the internet, that usually meant what is the employer's market? And if the non-compete was defined geographically to be smaller than that, it was probably okay. If it was defined to be larger than that, it probably wasn't. Today we live in a world with the internet, and so it's not entirely clear what courts are supposed to do with geography as a metric for assessing reasonableness. Um, but it's still clearly relevant. Um, as we said, the overarching concern is balancing these two competing harms: harm to the employee of enforcement. We don't want to render people unable to make a living on the one hand. On the other hand, um, the harm of not enforcing these provisions, because the employer really might, in some cases, be hurt if a valuable employee goes into competition with them. All right, number 3, what do courts do if they conclude that a non-compete is unreasonable? Well, they've developed 4 different approaches. The first is that they might be considered to be wholly unenforceable. This was the law in Wisconsin prior to Fullerton Lumber. And you can see what the problems are, right? I mean, if the choice is all or nothing, that might leave courts pretty uncomfortable, because it means it's imposing harm on one side or the other. Number 2, courts might do what the Fullerton Lumber Court ended up doing, and that is blue penciling in a different provision. Blue penciling is just a metaphor for rewriting term in the contract. So in Fullerton Lumber, the court said, well, 10 years is too long, but 3 years isn't. And so, in effect, we rewrote the contract, which is sort of an extraordinary thing to do if you think about it. If we believe that contracts reflect the will of parties, their intentions, the court isn't a party, so how are they supposed to know? But nevertheless, there are reasons, I think, that justify it in some cases. Number 3, some courts will enforce subject to some kind of balancing test, which you see discussed in the Johnson note case from Nebraska. And finally, some states, California in particular, simply declare non-competes wholly unenforceable, whether or not they are reasonable. In those cases, it's I think the public policy of the state, as reflected in the statute, that non-competes are sort of per se harmful to employees, and so they will not be enforceable on those grounds. Again, there may be other related provisions in employment agreements that are enforceable, like prohibitions on soliciting coworkers or taking customer lists or other proprietary information. And courts in states like California do enforce those. That is all we need to discuss now. That's the real deal on covenants not to compete.